Thanks for the papers. I look forward to reading you. I don't know how this grand experiment is going to work out, but as soon as I've digested enough of these in the next couple of days, we'll talk about it on Thursday and how you resolve the issues, how the court might resolve the same issues. It was a very challenging assignment. I belatedly figured out. Congratulations to you on hanging in there and not complaining, at least to me, about what an awful assignment it was. Today we'll talk about whether those 4 words in the First Amendment mean anything. Congress shall make no law abridging the freedom of speech, comma, or of the press. Do those words have any real world meaning, or are they simply surplusage, can be ignored, have no effect on the freedom of the press, because the press has free speech too, like all of us. And so the question is, does the press have any rights attributable to the explicit mention of the press in the First Amendment? And you see 2 points of view in the reading. Oh, well, I can't do that right. With Justice Potter Stewart reading into the First Amendment a structural protection for the press. After he wrote the opinion in the Pell and Saxby cases, the one that involved the prison rules against the press singling out individual prisoners for interview, in which the court upheld those restrictions on the press. After he wrote that opinion in 1974, he went up to Yale and gave the speech that you see reprinted in the Reader in the form of a law review article. He tacked on some footnotes onto the speech, and it was published as a law review article that next year. And I have to think that giving that speech, publishing that article, was caused by his discomfort with the result in Pell versus Saxby and his sort of continuing intellectual attempt to sort out these issues. After all, he had been friendly to the press, in many cases, friendly to the First Amendment, and probably didn't like the criticism that he got after Pell and Saxby, where he basically said the press doesn't have any special rights over and above those that we all have under the First Amendment. So he comes up with this speech in which he says that the primary purpose of including the mention of the press in the First Amendment was to create a sort of 4th branch of government, an institution that stands in an adversarial relationship to the 3 actual branches of government, stands outside them as a check and balance on the exercise of power by the 3 constitutionally recognized branches. The established press, he called it, is this kind of de facto 4th branch of government that provides organized expert scrutiny of government and has special status conferred on it by the First Amendment. And he says if the press clause means only that the freedom of expression by the press is protected, it's a redundancy, because the press, like all of us, has the freedom of expression, the freedom of speech. And that would be, why would the framers write a key provision of the Constitution that is redundant? So it must mean something, and in Stewart's view, it is a structural provision conferring on the established press a status that the rest of us don't have. And one of his themes in the speech is that the press is given an autonomy by the First Amendment. Its recognition as an institution gives it an autonomous status, somewhat like the other branches of government. And if it weren't autonomous, independent, and protected by the First Amendment, government regulation of the press could be routine. For example, the government could require the press to be neutral, be sort of a neutral marketplace of ideas, be required by the government to publish all views, not to take a particular editorial stance that the editors and publishers might have, but to be a forum for the entertainment of all views in the community, sort of like a public utility. It has to carry everybody's speech. That's a possible outcome. You can imagine a system in which the press is required to operate in that way, and it might be that it would even be consistent with a self-governing democracy, that you could have a press that was so regulated by the government as just to be neutral, just a conduit for the views of the community. But Stewart says that this autonomy that it has is not going to be treated as a public utility. The press can make their own decisions about what they publish, but the autonomy cuts both ways. They're free of the government to publish what they wish, but they can't require the government to cooperate with this autonomous entity and provide the information that the press wants to publish. Once they get the information, of course, they can publish it, but the government is under no obligation to support this autonomous entity by providing information that it doesn't want to. And Stewart says, memorably, the First Amendment is not a Freedom of Information Act. That is, it does not require the government to tell the press anything, or to give the press documents, records that show what the government is up to, or to give the press access to government information or facilities. For that point, that the Constitution is not a Freedom of Information Act that does require the government to give all of us certain records. To justify that point, he cites his opinion in Pell versus Saxby, that the press doesn't have any rights over and above the general public. Well, that's Stewart's argument, and it got a lot of currency, was cited by a few courts that involved press-related issues. But then a few years later, a devastating rebuttal was written by Anthony Lewis, the former New York Times columnist, reporter, and scholar on the First Amendment, where he said that what Stewart has done is basically say that the First Amendment prohibits Congress from abridging freedom of speech or of the news media. He hates the word media, but when you say news media, we're talking about the established press, what Stewart was talking about as the established press. And what Stewart actually said, what he said was that the publishing business qualifies for special First Amendment status. Well, Lewis takes issue with that. Says Stewart was all wrong, that isn't the meaning of those four words at all, and that the validity of Stewart's thesis about what the First Amendment means should be tested by the sources that Stewart used in his speech. That is, by history. Is the thesis supported by historically accurate fact, by the decided issues, the decided decisions of the court, which Stewart relied on, and by policy, sound public policy. Would it be sound public policy to give the press a preferred position under our Constitution? So starting with historical accuracy, Lewis, who's not a trained historian, he's relying on secondary sources, the literature. He didn't go back and look at whatever scribbles the framers might have made at the time, but he's read all of the relevant history, and he points out that when the framers in the late 18th century used the term press, they didn't mean just newspapers. The established press included not just newspapers, which were a relatively recent phenomenon in the late 18th century, but they also were conscious that the press included the publishers of books and of pamphlets. And remember, during the American Revolution, the pamphlets of Thomas Paine, Common Sense, that were enormously influential. And the framers certainly had in mind, when they wrote the word press, that the publishers of books and pamphlets, not just newspapers, would be included for that protection. Lewis points out that, which other scholars have noticed, that there really isn't any definitive legislative history by the framers of what they meant by the press. There isn't any contemporaneous account. James Madison he preserved his notes of the Constitutional Convention, although he kept them secret for 35 years after the convention. They weren't published until his death. But the framers who wrote the First Amendment didn't leave behind any trace of what they actually meant. The way Congress would do these days, with the whole hearings, various people would speak on the floor about what they meant, and you'd have a good legislative record of what they meant. Well, that doesn't exist about the First Amendment. So too bad for Scalia and Thomas. There is no solid evidence of the original understanding of the framers on what they meant by using the word press. There is and Lewis, being an intellectually honest person, mentions this, there is this circumstantial evidence of the importance of the press to the framers, which is that 10 of the 12 new states, former colonies, 10 of the 12 constitutions of the states carried an explicit protection for freedom of the press, and they didn't mention freedom of speech, as though press was more important than speech at that time. The press was singled out for special mention, one speculates, because the press had been the target of prior restraints back in England, of sedition prosecutions, including in the United States, like the prosecution of John Peter Zenger, the printer in New York, in 1735, who was prosecuted basically for seditious libel, and for various kinds of censorship. So maybe because the colonies and in the new states knew that the press had been subjected to these kind of things, that they didn't want their new democracy to include, that is, restraints, muzzling the press, prior restraints, censorship, and so on. Maybe that's why they included the word press. But that's just speculation. We don't have anything contemporaneous to show. Lewis concludes that the most likely reason that the framers included or of the press was simply to make it clear that written expression in the press was protected as well as oral expression, the freedom of speech. That, to me, seems completely lame. That clearly the framers, look at the evidence of those 10 states that include protections for the press, but not for speech. How could the framers be thinking, oh, well, we just want to make sure that something that's written is protected, not just something that's oral? But on the history, it certainly is true that the framers, by using the word press, meant something more and different from simply newspapers, which is the way Stewart uses it in his article. So then what about the court's precedents, the decided cases of the Supreme Court that Stewart relies on as establishing his thesis? And this is sort of a good review for you for this course, because these cases are bedrock ones that we either have considered in detail or will. Sullivan, New York Times versus Sullivan. And Stewart says that was an important protection for the press, to be free from libel suits when the press attacks public officials and public figures. And that's true as far as it goes. But Lewis points out that the court in New York Times versus Sullivan never mentioned the press clause. It simply said this involves the rights of freedom of speech and of the press under the First Amendment. And there was no recognition that the press clause governed this case. And he points out that this wasn't simply a press case protecting the press, because remember, there were the 4 preachers from Alabama who were sued along with the New York Times, and the court's decision in Sullivan protected them, relieved them from the libel judgment against them, as well as the New York Times. So the individuals were protected. But then the really key point that Lewis makes is that the rationale for the court's decision in Sullivan was not, we've got to protect the press against libel claims by public officials, but we have to empower the citizen critics of our nation to be able to criticize their governors, the powerful people in our society. The citizen critic, that's the word that Brennan used, taking it from Justice Brandeis's wonderful opinion of Whitney versus California. The whole theory of our system is that we the people are in charge, And we have the right, if not the duty, as citizens, to criticize government. And that was the rationale, Brennan says, used in the Sullivan case. The central meaning of the First Amendment, he said, was crystallized by our experience with the Sedition Act, establishing the right that we all have to criticize government. So much for Sullivan. What then about Brandsburg versus Hayes? Those of you who have been right on it all along may remember the Brandsburg case. That was in 1972, involving Earl Caldwell of the New York Times and some other reporters who wanted to protect their sources against coerced disclosure to federal grand juries when the grand juries were investigating crimes committed by others. And they subpoenaed the reporters, and the reporter said, no, the First Amendment protects us against compelled disclosure of our confidential sources, people to whom we have solemnly promised not to disclose their identity or information given to us in confidence. And the case went to the Supreme Court, which decided 5-4, there is no First Amendment protection for reporters against compelled disclosure of their sources. And the court treated reporters like all of the rest of us who are subpoenaed to testify before grand juries. We don't have any privilege not to testify, other than the recognized attorney-client doctor-patient, those kinds of privileges, but simply because we gave an assurance of confidentiality to someone who doesn't give us the right to say, no, I'm not going to answer that. And the court refused to carve out an exception from that general obligation that all citizens have for reporters. Well, somehow, Stewart takes away from that decision that Brandsburg recognizes the separate, independent, protected status of the press under the First Amendment. And he said if there weren't explicit recognition for the press in the First Amendment, then it wouldn't even have been an issue. That Brandsburg, Caldwell, the reporters wouldn't have had a leg to stand on because all citizens would be required to testify. And yet, Stewart saying the court took it terribly seriously and split almost evenly on whether the press had any protection. Lewis says that's a situation in which the press lost the case and lost the argument that the press has any kind of special protection under the First Amendment. And Lewis points out that would Stewart say that there should be a difference between, say, a reporter who's brought in to testify and an academic researcher who may have given, doing the research, doing studies, may have given assurances of confidentiality to the subject, and all of a sudden is hailed into court and required to violate those assurances. And Lewis thinks that clearly that wouldn't be treated any different than a member of the press. Then there's a case that we haven't considered yet, but we will next Tuesday or Thursday, Miami Herald versus Tornillo, pardon the pronunciation, but that's the way the guy pronounces his name, Tornillo, who was a union official in Florida who was running for the Florida legislature. And the Miami Herald wrote an editorial attacking Tornillo as incompetent and corrupt and so on. And he requested, under a Florida law, the right to reply to this editorial. And sure enough, there was a Florida law that gave candidates for office who were attacked the right to reply in the newspaper, in as prominent a place as the initial attack was, and rebut the attack that the newspaper had made. Case went to the Supreme Court, and the court decided that that statute was unconstitutional, was a violation of the First Amendment, for a couple of reasons. We'll look at it in more detail next week. But the reasons were that, the Chief Justice Berger gave in the opinion, were that this law imposes a penalty based on the content of the newspaper's speech. That is, the penalty is they have to give up space in their newspaper that they could either fill with their own editorial content or with advertising to somebody whose speech they don't want published. And the penalty of having to devote time and money, space, to a speech that they don't want is a penalty based on the content of the speech and is therefore unconstitutional. But Berger also said that the law is unconstitutional because it intrudes into the function of editors. And newspaper editors are not simply the passive receptacles of information who will stick it in the newspaper. They exercise judgment. And that exercise of judgment, of discretion about what should be published, is one that the First Amendment confers on newspapers, not state legislatures, not outsiders, not people who want to get their information published in the newspaper. That's about as close to recognizing a special status for the press as, in my view, the court has ever come. But even in Tornillo, Miami Herald versus Tornillo, the court did not rely on, didn't even cite the press clause. Didn't say that because the press is recognized as having structural protection under the First Amendment, we decide that Florida can't do this to newspapers. Didn't do that at all. And Lewis concludes, which I believe is correct, that the rationale of Miami Herald versus Tornillo would apply to any of us, to any individual who's writing or speaking something, not just to newspapers, that none of us can be required by government to say things that we do not believe. Remembering cases like the